Kirk is not an attorney. This is not legal advice. This is to be considered for educational purposes only.
Welcome to Kirk's Law Corner, live with your host, Kirk Pendergrass.
Good evening, folks.
There's Ted.
An interesting week. And with the guest that we thought maybe we're going to have on here tonight, Nathan Altenhofen, he'll be on Wednesday night. So we're going to be trying something a little different with the events deals. We'll be going live from the events. So we're going to get that set up. So if you're subscribed to the event as going, and it'll be a reoccurring event, we'll be going live from the event to kind of eliminate that trying to find us thing, and we won't have to do so much sharing. Of course, we'll still do sharing, but it'll make the sharing easier because we can share the event. And so that's going to be the new setup tonight. I didn't quite get it set up right yet. So we have Christopher Hallett, E-Claws here tonight, and we have John Gentry. Chris, how you doing, brother?
Not too bad, man. What's going on, Kirk?
You know, reading words and stuff, the King's English.
Words and stuff. I love it.
How about you, John? How you doing?
Fighting the fight, trying to keep them on their toes.
Right. Now you're battling it out there in the federal courts, right?
Yeah, I've actually got 3 projects I'm working on, getting ready to start on a 4th. But I've got 2 cases in the Supreme Court, one in the 6th Circuit, which is the same case, and then I've got another one in the Tennessee Supreme Court asking about the lack of enforcement of perjury statutes and whether that's a violation of equal protection for the victims of perjury.
Yep, and we're still working on. We're going to create a video to share out there for the special project that we're all collaborating on. That's that one individual from every one of the 50 states, and we'll do a. How did you word that? It's basically the people of the United States versus the United States of America.
Yeah, so we're going to take one good litigant from each state. They can join as many other plaintiffs from their state who care to join it. And we're going to take it straight to the Supreme Court of the United States. We're not going to mess with the district courts or the circuit courts. We're going to go straight to SCOTUS and say, we can't enforce our rights anymore. The courts are no longer put in place to serve justice. They're there to create billable hours. And we would like some reform as guaranteed in our constitutions. And then we'll see what, and I think coming in with people from across the country, 50 states, the people of 50 states asking the Supreme Court to reform the governments of 50 states. And I think it's something that's never been tried. And I think it's something that the Supreme Court will have to grant certiorari on.
Well, the other thing too that I think John is want to make sure that we make clear, this project is going to involve people with comprehensive solutions, not just to stand there and go after any one particular person or that type of thing. It's like, here's the facts, here's what happened, here is my proposed solution, to remedy this problem, right?
Yeah.
And I think between all 50 states, we can help them we can provide them with enough information that, like John says, it will basically force compliance with our form of government. And, the fact that we have constructed some of the mechanisms that we've already constructed is, a clue that, the people are watching, and we've been watching for a long time. So as far as bad actors are concerned, well, bad actors are bad actors. We'll handle them as we handle them, depending on their capacity. So, but in the here and the now, it's give them a comprehensive solution that solves the problem without casting aspersions on somebody else. I don't know if that makes sense, but in other words, it's like, look, this is in the past. I know it. You know it. Can't change it. Here's what is written. Here's where we are. Here's my proposed solution. Here you go. What do you think? And I don't think there's anything wrong. I don't think that I don't foresee them saying, get out of here, kid, you bother me. I mean, even if they just take it and they say, well, because you're not asking for any monetary relief, this is only reform. It's going to be, it's going to go down however they want it to go down. So, but I think it's at least a step in the right direction to getting our foot in the door to say, okay, that's it. You had your time to put your toys up, get ready to go to bed. Right. So, I don't know any other way to put it, but.
Right. Well, we have not only the right, but the duty to throw off this despotic government and institute new guards for our security and safety. It's not just a right, it's a duty. People, we need people to read. Here in Idaho, we got lucky. We got a Secretary of State that puts this kind of stuff out right here. And you can read it. I mean, it's the Idaho State Constitution, the Declaration of Independence, and the United States Constitution. I mean, we've got to get people to read. And I know that's part of what we do here is we're trying to educate the people. I've put out law.cornell.edu. That's a great place to go to look at the Constitution because it has the explanation part, which takes you right to the annotated Constitution. And the annotated Constitution is, hey, this is what this means. Now, I've found some discrepancies in there. So you kind of have to read between the lines on some of it, but there's some pretty good stuff in there that does explain it how it should be. And then there's some stuff that doesn't. But, we need to get people educated. What do you got, John? Your mic's.
Okay, yeah, that's what we're asking for in this suit against the states is it's the same thing our founding fathers demanded when we declared independence. We want due process. We want to be able to enforce our rights, and we can't do that right now. And so we're going to be seeking, very reasonable reforms. If you get into a proceeding and you find that your rights are being violated and that you have a biased judge, that you can just say, time out. I would like to call and assemble a jury to decide this matter. That's guaranteed in most state constitutions. It's a right that's denied to us right now. And so we want to ask the Supreme Court to reassert that right and order the states to guarantee that to us, because the systems that we've got in place right now, they just aren't working. You file a complaint against the judge, 100% of the complaints get dismissed. We've already proved that in a report to Congress that 100% of the complaints get dismissed. You take it to the federal court and they dismiss it, sovereign immunity, judicial immunity. Even when you're seeking only equitable relief, only enforcement of a right of due process, you still get dismissed. And the same thing happens in the circuit courts. So we're going to ask the Supreme Court, okay, if these things are true, how do we enforce our rights? How do we assert our right of due process? And so I think that's a pretty reasonable reform. And, you know, one of the as part of our causes of action, all of the states, I think every single state has enacted statutes that are unconstitutional. And so we're going to ask the Supreme Court, hey, these laws that the state has enacted are enacted to protect corruption, to prevent us from asserting our right of due process. And we would like you to decide, are these laws constitutional or not? We don't think they are. And when we file a complaint against the Board of Judicial Conduct, or whatever the agency's name is in your respective state, and 100% of them get dismissed, we would like to take that to a jury and let an impartial jury decide from the jury pool whether that complaint should move forward or not. These are, you know, we're not asking for money. We're just asking for a right of due process.
Yeah, I mean, due process of law. I mean, we're the ones here. We're supposed to be the master. Right? We're the masters as a representative. You're the servant. You're the public servant. That's how our style and form of government is supposed to be. Our style of government is we're self-governed. That's in the Declaration of Independence. That's laid down as the law of the land. So, we do have, I guess it looks like Brian might be trying to call in. So we were going to have Brian Van Akin on here in a little bit. I think that's, yeah. Okay. So at the half-hour mark here, we'll bring him on. And I've asked him to come on to explain his filings and paperwork that he's in SCOTUS and all this other stuff. He's got standing in SCOTUS, and he keeps posting this kind of stuff out there. And so I'm confused when he posts that stuff, because the stuff that he's posting just, I don't know, it just does that make any sense to you guys?
Well, I mean, you know, I've leafed through it. It's, you know, like you said, it's almost like watching another loop in the loop-de-loops, you know. So like right. You, I'm, you know, trying to understand it, and it's hard to figure out where he's going with it. But,
yeah. So well, let's see. He's on. Let's bring him on. Are you ready for this, Ted? Okay. Shaking his head, yeah, from there. Do want to put out the thank you to Ted Fogg here. Our producer is back. He rocks this stuff out there. He does an awesome job for us.
Yep,
and love you, Ted. The March Us is his personal group page over there, and he's doing the Nancy Schaefer deal out there in Georgia. Yep, Georgia. So, you know, Nancy Schaefer, she's the one that was trying to expose this corruption in the CPS realm of things in the parental rights area, and she got murdered. So this is going to be a deal there March 15th, 17th, somewhere around there. It's March 25th, the memorial for her. There's going to be quite a few people there. So if you can make it out to Georgia to help support Nancy Schaefer and her efforts, and just a memorial for her, you know, that's another one of those people that's trying to stand up to corruption and got murdered. So, you know, it's difficult times out there. I mean, even with what we're doing, you know, one positive thing about this is Chris has gone through the federal courts. He's gone to Congress, and they're at least working with him now, and they're loving it. I mean, can't break it down to simplicity. It's mathematics. It's calculus. You know, -1 times -1. That's the two negatives that go into the court, and then it equals a +1, and that's what the judge sees. So you get one person, the moving party, who lies, makes false statements, times that by that attorney. That's a double negative, and it goes in front of the court, and the attorney's like, yeah, this is all good. This is all good. And the judge knows no different. Unless you're on the other side going, whoa, wait a minute, objection, Your Honor. Mr. blah, blah, blah is attempting to enter facts on the record that are not in evidence. But if you have an attorney, that's your attorney over there screwing you over by not making that objection and saying, yep, yeah, I'm looking over here and looking over there. I don't see anything wrong with this paperwork. But I'm here to attorn this, man, because you're an infant basically. When you hire an attorney, you're not sui juris. I'll just use the proper term. You're not sui juris. You're not of law. Well, considering what sui juris means to them, when you hire an attorney, you're not of lawful age. You're not of sound mind, and you're not capable of taking care of your fiduciary duties. So
well,
you're right. You're right to impose a duty not only on yourself but on any other man who. And when I say man, mankind, not woe man and man. So,
well, just to clear something up, because the fiduciary element to the practice basically says that this practitioner is standing with his or her client. Okay.
Supposed to be.
Well, right. And this is a perceived relationship when you hire somebody that you believe I'm paying this person to do this job. Right here, like many of us have done. Here's you want this? Here it is. Go to work. And then when they find out, or when we find out later on that that's not what happened, okay. By that time, you're usually so beat up, you're not really paying attention to what's going on. Well, I took that fiduciary duty, and we've discussed that, and how all of that came into being. It is what it is. It happened that way. But
under sui juris, you have a fiduciary duty.
No, the person has under sui juris. It's not about their fiduciary. It's about their right to present their defense.
Right.
Right.
So that wouldn't be a fiduciary duty?
No. The fiduciary duty is my duty to stand with my client, bear witness, or assist.
So when you're taking responsibility for representing somebody else's rights, that's a fiduciary.
No, well, it's assisting, right? Assistance of counsel, right? Remember, what's in a name? So when you're talking about assistance of somebody who's qualified, and one of the differences between my practice and the current mechanism is all of that is all one thing, right? They don't examine the pieces and parts of the courtroom the way we do. So again, I go back to this as a parts guy, I go through and I examine every single part of this thing and do a systems analysis on it, which is what I've done, and said, look, here's where the wheels came off of the wagon. What are we going to do to fix it? So that's why I say don't just go in there and bitch and complain. Give them a solution. Give them something they can wrap their head around.
Right. But there is, under sui juris, you have a duty to perform. And, I noticed it can be worded as administrative duty to file your paperwork and to make your arguments. I just assumed that it was under the fiduciary duty. I'm talking about it. So just to clarify for myself and maybe people that are watching, so fiduciary duty only applies, that fiduciary part is based on somebody else doing something for somebody. Correct.
That relationship, that means I'm working on behalf of my client, and I'm going to give every bit of my knowledge to act in concert with my client. My practice is not attorneying you and giving you to them. That's not what I do. What I do is I say, look, here's the circumstances. I don't like it any more than you do. Neither does my client. Here's what, right?
Yep.
So I'm not attorneying them. I'm bearing witness, and based on my knowledge of this subject matter, whatever it is, could be divorce issue, could be brake related for, brakes on a car. Who cares? But if it's something that I'm qualified to speak on, that's my ASE certification. Ask someone else. So, qualified to speak on brakes. So,
Lorraine,
that type of thing. That means that's giving the court an educated, comprehensive analysis of what happened based on a specific qualification, and pick one. There's many to choose from. To, take us from where we are to where we need to be, and, be done with this. Not take it and roll it over and over and over and over and over and over again. So that's what I mean by how we've digressed back into where we started, 230 some odd years ago. So, but that's where the adding the fiduciary element and equalizing the practice of law, right?
Yeah.
So it removes that element of confrontation between the practitioners, right? Because both know that their fiduciary duty is to their client. The court knows the fiduciary duty is to the client. And when you're working the equity scale, which is what the current family law emolument is based on, that requires credentials. That's in law. So for them to come out and say, oh, I'm qualified, no, you're not. You can't even provide a comprehensive defense because of this other relationship, and you're going to say that you're qualified. No, not buying it, ain't happening. So,
this is the thing that astounds me about our courts today is you walk in there and I'm pretty articulate and I know how to read quite well. I'm a certified public accountant. Court rules are not so dissimilar from accounting rules. They're as you get in the more complicated accounting rules, the court rules they're not so different. And so I walk into court and I say, well, can I respond to that? And the judge says, no, you may not. And that was how I started in this process. I didn't even realize that my rights were being violated. When I said, can I respond to that? He said, no, you can't. I didn't even realize that was a violation of my right to be heard in the beginning. It's just like, okay, I'll be quiet, And then as I started researching this, and I think that's the hard thing for people to understand out there is breaking it down the way you guys have. And understanding your rights, understanding where the breakdown in the process is. Maybe that breakdown is you didn't get a chance to present your evidence. Maybe that breakdown is fraud on the court. Maybe that breakdown is perjury that was introduced to the court. Maybe it was false arguments of law by opposing counsel. But understanding the fundamental issue of where your rights were violated. Because I can tell you, our courts are about fairness. And when you walk into court and it's like, this doesn't seem fair, not only does this not seem fair, this seems like a great injustice that's being done to me. There's nothing fair about this. And when you get that feeling, you can be assured that due process is not being followed and that your rights are being violated. And so from that point, then you articulate and you say, well, here's where the process broke down that Chris has walked us through several times. Here's where the process broke down. And then you bring it to the court's attention. Here's where the process broke down. And if the court doesn't want to listen to you, and perhaps the court is bent on abrogating your rights and is maybe even perhaps in conspiracy with opposing counsel, then you just take the issue to federal court. And that's a pain. But you can walk through that process in federal courts, and we've got documents that we're happy to help you guys with if you want to take that route. And I strongly encourage people to take that route. Everybody says, oh, they're just going to dismiss you in federal court. Don't even try. Don't do that. Don't fall into that. That's what they want you to believe is to don't try. Get in there and evidence the rights violations that are happening to you and demand enforcement of your rights. And we're all about teaching you guys how to do that.
Yeah. There's some key things for people to read. And one of those things is the
Kirk done froze.
Yeah.
Just give him a second.
No. Wonder if he was having technical difficulties. he said was saying earlier on the phone, he had like 10 different screens going at the same time. He's fighting a lot of this same stuff that many of us are fighting now. And, you know, so having spent, you know, multiple hours on the phone with him going over this same exact thing, you know, versus when he first started this, it was just about the law. So now it's, you know, seeing this from the practitioner's table, right?
Mm-hmm.
Because before it's just, he's doing the systems analysis, right? Starting out with, well, what's it say? What's it look like? Well, that's not what's here. So,
right.
But, you know, it's one thing to be, you know, that's my favorite argument with, you know, within my family unit is there's a difference between theory and practice. I'm the practice. I talk about that. I already know the theory. I studied the theory. So
let's see here. Sorry, guys. I'm trying to get your camera straightened out, obviously. Let's get rid of that. So, John, I thought we were already Facebook friends. I tried to tag you in tonight's video, and it didn't tag. I don't know why I couldn't find you. So I sent you a friend request.
Yeah, I got that. I confirmed that today.
Okay,
So,
cool.
official, you liked me, huh?
Yeah, I liked you, or I friended you. But anyways, I for tonight's broadcast on Kirk's Law Corner, I couldn't, like, if I'm broadcasting on the page, on the Kirk's Law Corner page, they usually freeze up all kinds of people. Maybe I should have pressed @. It's been a little while. I bet if I pressed @ you would have popped up, even though we weren't Facebook friends. It's weird though, because I thought we were already Facebook friends. Maybe you have a duplicate account. I don't know.
he's been a-torned.
He's been a torn.
Ted Fogg, do I have volume?
You do? Is that Brian?
There's
Kirk.
Kirk messaged me.
Okay, cool. Yep, you're on. Kirk is back on. Let me fix these cameras again.
I just been respectful.
Oh, thank you. I am going to...
Gotta love computers, man. They kind of do their own thing.
I hear you. This is the weirdest thing. I need the host back to get the camera straight, and since you somehow logged in as me, I can't get the host back.
Well, let me make you there. How's that? Wait.
There we go. Let's see if I can do
sorry
this.
for technical difficulties here. It's never really flawless.
We try.
Getting into reading your judicial canons, you know, and this is something I've just recently downloaded and taken me a little while to get to it. But, you know, I was reading some of them this morning, and it's, you know, you have to follow the law, Judge. You have to give the other side opportunity to make their defenses, especially people that are, you know, they call it self-represented, which I like much better than pro se litigant, because pro se litigant, they try to hold you to the same standards as an attorney. But you read the judicial canons, and it says the judge is not supposed to hold you to the same standards, okay? So they're supposed to actually be pretty lenient with you, because we're supposed to be the common folk. And then part of the problems we always see is they try to tell us what the law says, right? I see it even here in the comments, you know, well, they say they have sole discretion and take away the right, even if you do. This is where you got to get in and go, whoa, wait a minute. No, okay. Best interest of a child only happens once you meet that governmental compelling interest, which is something we talked about last week, is that strict scrutiny standards, like thread and needle in the dark. You know, in order for the government to reach through that eye of the needle, they have to have certain elements, which is food, clothing, shelter, and abuse. And they like to try and construe that abuse as anything. No. It has to be of eminent danger and threat of death. Okay, not that you spank your child, or you've got a few dishes in your sink, or you've got toys scattered all over the floor, or your walls are a little bit dirty. That's not imminent threat of death, harm. No. So it's kind of knowing what that really means. It's holding their feet to the fire. Okay, I'm gonna put some fire under your feet if you're gonna sit there and tell me that you have my son's best interest and that you can make whatever orders you want based on that. I'm gonna say, no, you don't. My right overstands your authority. You don't have that authority. You're an umpire. You're to call balls and strikes here. So I'm gonna put you back in your place. You're an umpire. Moving party has to make the argument. Okay, they're the ones, and then you're supposed to go, is that a fact of law or is it not? And if I'm objecting to it being claimed as a fact of law, then somebody's got to prove that it's a fact of law. The burden of proof's on the moving party. So if you object to, well, we have, no, you don't. Objecting, attempting to enter facts into the record that are not in evidence. Show me the evidence that says you have the best interest of the child at stake here. You don't have that. Oh, now Chris's went down. It's a Windows 10 thing, I'm telling you, because this machine over here, I've got two machines here, plus my phone. Chris's and mine both are running Windows 10. It's kind of funny. Some of these things happen at the same time or relatively at the same time. So it's got to be a Windows 10 thing.
You know, that's touching on what you said, Kirk. I bet you every per se sui juris litigant out there has said, you know, hey, here's what the law says, here's what the rules say. And the response from the court is, you don't know the law, you're not an attorney. And what I say back to them is, you know, really, I don't need to know the law. You do. You know, you're the judge. The Code of Judicial Conduct says you're supposed to be knowledgeable in the law. I just need to show you. I just need to show you the facts. That's all I need to do is present the facts to you, and it's your job to rule according to the law. So whether or not I know the law doesn't matter. You need to follow the law, and then if they don't, then you take it up with a higher court, test it out in federal court, and push it and see if you can get them to follow the law and follow the rules.
Yeah, you know, they're supposed to be the ones that are deemed to know the law. And here's the part where E-Clause comes in is, well, Brian, why'd you hang up? We're going to bring you on here in just a minute.
I didn't hang up.
Oh, okay. And you got sound now. Sweet.
I've always had sound.
Oh, it didn't show a mic over here on my board. Okay, so hold on there.
That's
okay. You know, the thing is oh, crap, I lost my train of thought. They're deemed to know the law. And this is where E-Clause comes in, is these, you know, they're held to a different standard, and it's something that we're trying to basically discover, or not discovered, but basically these are admiralty courts, right? Admiralty jurisdiction courts. The thing is when these public servants become public servants, they're under admiralty jurisdiction. And this is part of tying into the executive orders, the human rights violations and human trafficking, how they can come in and seize their property as a public servant when you trespass the law. They can seize their property without due process of law because you're already deemed to know the law as a representative in government, okay? So you're held to a higher standard if you're a representative in government, if you're a public servant. And I'm talking clear down to the meter maid, to the CPS worker. This brings up another thing, you know, as a government employee, you're required to have 3 forms of identification. 1, your personal identification. Number 2, the agency that you work for must supply you with identification. And here's the big one, your oath or affirmation, your oath of office. What position are you holding? And you are supposed to be bound by oath. Read it, Article 6, not Clause 2, Clause 3, okay? Clause 3 says everyone from the legislative branch, the executive branch, and the judicial branch. That's the only three parts of government we have here. So that's laid down as the supreme law of the land. You shall be bound by oath or affirmation to support this Constitution and the state constitution, because those two things are ordained or established. The supreme law of the land has to be ordained and established. So knowing this, if you get this in your mind, they're the ones that are deemed to know the law. They're not supposed to be trespassing the law. And when they do, you can hold their feet to the fire. Okay. So that's part of what we're trying to do here with E-Clause and getting people on board with that are knowledgeable on the law that can, you know, assist basically in helping others, even helping them get their paperwork together and put it in the folders right, get it all aligned out. Do a statement of facts. You know, this happened on this day, this happened on this day, this happened on this day, who the bad actors are, what date and time this bad actor did this. You know, get that all lined out, because if you want E-Clause to help you, Chris is only one guy. He can only do so much. Okay. So if you really want help from E-Clause, this is things that you can do to streamline that deal there with E-Clause, and he can go through your paperwork, organize it, and go, yep, okay. Write a little practitioner's judicial report, notice of special appearance, essentially, not a special appearance, but it is in a way, kind of like a third-party intervener, basically, and say, here's the law, here's who trespassed the law and when they trespassed it, and ready for this? Here's the tort claims. This is the crime. This is how much you owe in damages for trespassing the law and depriving this person. And in the appendix here is all your case file stuff. That's the evidence. So if you have all that, things can be streamlined, things can get done. And this is still a new process that's in the process of being ironed out and figured out. But generally speaking, this is something you can do on your own without E-Clause, okay? And that process has been provided by the Justice Department. You can go online, you can go to the Justice Department website, download the complaint form, and you have all your paperwork already done, you know. Make a separate copy of the findings of facts and everything that you would put together there, attached with your evidence, file the complaint, and send that in. You know, Jeff Sessions said that's what he's going to do. Anybody who files a complaint, it will be investigated. So under our new administration of government, we have to put this, what we've been subjected to for the last 9,500 years, we have to put that to the side. Things are different. This is a new era, new administration of government. And if you have taken a look at the recent executive order that just came out, March 1st or March 2nd, yeah, our military now is empowered to go in and arrest bad judges, bad police officers, FBI agents, BLM, Bureau of Land Management. Okay, so Trump is holding his word. He's holding up what he said he's going to do. And it's coming. This country is in for a serious, serious shakedown. It's coming. There ain't no ifs, ands, or buts. So,
amen.
Right here, drain the swamp. And that is exactly what Trump's going to do. Make America great again by removing the bad actors. Some of them will be going to prison. Some of them will be just as simple as, hey, you trespass the law here. You've done it for quite some time, and you're deemed to know the law. So you're going to have to resign, and you're going to lose all your benefits, or you're going to be criminally indicted, and you're going to prison. So that's your two choices. Now, people like us and trying to educate you folks, and you go in there with the law as it is written and you read it to them, okay, they have the opportunity to stop doing what they're doing is wrong, because back to that negative nexus, the judge may not really know. I mean, trying to give the benefit of the doubt here, okay, fraud upon the court that's why it's called fraud upon the court, okay, because the judge doesn't know that that's not true. And your attorney isn't doing that. So fire your attorney, or have a nice little talk with your attorney and say, you better start doing your job or you're next.
Yeah. You know, I saw a couple comments from Neely, and it kind of ties in with what you're saying, Kirk. But Neely said, go read the Constitution, go read your rules of procedure. And absolutely, you must do that. Just to give you an example, they extorted attorney fees from me under color of law, garnished my account, took the money from me. And when I complained about it, they're like, oh, he was sanctioned under Rule 11. And at first I just kind of took that like, oh, darn, they sanctioned me under Rule 11. But then I went and read Rule 11 and they didn't follow the rules. Rule 11 says that if an attorney is going to ask for sanction for attorney fees, there's a 21-day safe harbor rule where they say that the attorney is supposed to go to you first and say, you need to withdraw this motion or I'm going to file and request sanction against you for attorney fees. And so you got 21 days to withdraw it or refine it, restate it, do whatever. They didn't do that. They just took the money from me. The other way is if the judge issues an order to show cause why your motion is frivolous. And they didn't do that either. And so when they assert and they say, well, we're going to do this because of this rule, go read the rule. And many times you guys are going to find they can't do that crap. There's protections that are built in for all of this stuff. And these guys know that those protections are there. They're circumventing the rules to deny us due process. So yeah, Neely is right. Go out and read the rules of procedure. Go out and understand. I mean, the Constitution, Bill of Rights are not long. You can read them in 10 minutes from across every state and say, oh, well, these are my rights.
Right.
And then you go to the judge and you complain that my rights are being violated here. Let's get this back on track. And if they don't, then you raise the issue in federal court, or you evidence it into the record. You complain via motion, memorandum of law, and say, here's what the Constitution says. Here's how the Constitution was not followed, or here's how the rules of procedure were not followed. And then that gives you issues to raise on appeal, or it evidences in the records that you can take it to federal court, one or the other.
Yeah. And again, we go back to the first court that you go into. That first court that you go to, whether it's a traffic ticket, so we're talking infractions, or the misdemeanor courts, criminal courts, even the felony courts, or the family courts. Those are all designed to violate your basic fundamental human rights. They are designed to traffic you. They use charging instruments, okay? And this is part of the executive order, human rights violations and human trafficking. There's two parts to human trafficking. Section 1 is the sexual side of things. Most common thought when somebody says human trafficking, you think, oh, you're talking about sexual slavery. Yep, you're right. But there's two parts. The second part is debt slave, okay? And if you don't understand the birth certificate, the social security number, and all that stuff, which is a whole nother rabbit hole in and of itself. But the simplicity of it is, okay, it's a constructive fraud, okay, to build this trust for you. They create a trust, and there's all sorts of money in your trust, and that account number is on the back of your social security card. Those red, the first letter is your zone routing number, basically, and the rest is your banking information. That's what they're discharging the debt on these charging instruments from. So
that's the ratchet.
Yep, they're designed to run you through the machine, grind you up inside, wring you out for everything that you got, and spit you out the other side. To take your house, to take your car, to take your motorcycle, whatever it is. It's designed to put you in further debt when you have all this money out there. And they don't tell you that. They don't tell you that they created 3 different bonds in your case so that they can discharge your debt. And if you don't pay it, there's other things that can go on there. But, the reality is the first courts you go into are designed, by design, okay, to traffic you. So you have to file the appropriate paperwork. I go back to my analogy of, remember back when we were in grade school, we were taught to raise our hand. Okay, that's part of sui juris and that administrative duties that you have to perform. You have to file your paperwork, and the first thing to file is a notice of special appearance, objecting to the personal jurisdiction. Okay, So basically you're telling them, no, this isn't lawful. And in fact, this is human rights violations and this is human trafficking. And here's how it's human trafficking. But really, the reality is when you object to jurisdiction, that burden of proof's on them over there. They have to prove that they have personal jurisdiction. They have to prove that they have subject matter jurisdiction. And we go back to, there are 7 elements of jurisdiction: locus jurisdiction, venue. There's a couple more that I can't think of off the top of my head, but
standing. Hello.
well, that's personal jurisdiction, isn't it? Yes, no. It could be another separate element in and of itself. You don't have any you don't have a right to a cause of action here.
Right.
Who are
remember
you?
remember the bar fight incident? Yeah, remember the bar fight example, right?
The what?
You're sitting at a bar, having your beer. I walk up behind you and punch you upside the head. You take me outside, clean my clock, and then I try to sue you for those damages. I can't sue you. I don't have clean hands.
Yep, that's a clean hands doctrine.
Right. So I don't have standing under the clean hands doctrine to even sue you.
Yeah, and
because
that's actually in the rules. In the rules of procedure, they call that a right to a cause of action. So you have to actually, in order to have standing, you have to have the right to a cause of action. So if I don't cause injury or harm to you, you don't have a right to a cause of action. And then if we apply the clean hands doctrine in that scenario there, you're the one that started it. So you have dirty hands. You don't have a right to a cause of action. Okay? So you don't have any standing here. And then, things like in my situation where, mother takes off with the child, who has standing to a right to a cause of action here? Not her.
Right.
I'm the one.
Which is, where do you want me to do the 2 scales on the whiteboard for some of our?
Let's get to that. Let's bring Brian on here.
Let's get Brian on. Get through that.
Video. Brian.
Yeah, I'm here.
With us?
Let's get Brian on, then I'll do the whiteboard.
Absolutely.
All right.
Hey, thank you guys.
So
go ahead, Kirk.
You're filing stuff in SCOTUS and all that stuff, right?
That's correct. Unfortunately, that is.
Right. So
it got that far.
What do you mean it got that far? Have you gone through the federal district court first?
I didn't sue anyone for a declaratory judgment. The federal court in a different circuit should have just given me answer my questions. Over.
Right, so, but you don't get to dictate that. They do. So your paperwork
correct.
is supposed to tell you what they decided.
Well, it goes back into what I did with the state court. The whole thing is I have to say one and two things. If we don't come together, and I'm a part of this, I don't want to do drama on social media. I do, just because I'm living in the moment and it's sad. I want to put out personal apologies. It's just, I live in the moment. Let's stick to what you're doing. We're not going to do this shit here. Okay.
Yeah. So what do you have filed, and how did you get there?
I piggyback on Hallett and Gentry. I mean, I was innocent. I didn't know. And then when I learned, I figured out the fraud. The same day that paternity was established, the fraud occurred. And I was going ahead with that because the fiduciary, which he discussed, the bottom line is, when you understand what they're doing to you, which again, it's all for profit.
Right. We're all up to speed on that kind of stuff. But
Yeah. So
that you say that you're in the SCOTUS, and you got that one piece of paper that you got a file.
Correct. I filed
a case number there. So I want to know how
I filed.
That's the process, is what I want to hear. I don't want to hear your story.
Got you.
I want to hear the process of how you got there.
So I exhausted all state remedies, and then I had no choice, and I used another circuit, but I filed in federal. And I was like, this is the bad actors. This is what's going on.
Okay.
That's where the federal said denial. So then I already knew that, and I already had a notice of appeal. I paid $400 for federal. I paid $505 to do the appeal.
Right.
What they're doing, this is all bankruptcy, people. They want you to not pay. What's unfortunate is I turned from like basically the ward of the state into sui juris. Now they're caught, they know it, and they don't even want to talk about right to honest services. So I'm paying federal appellate. Now I'm in Supreme. They're using processes that I have a legitimate claim in equity.
Right. But
So it's called equitable tolling.
Right.
It doesn't matter about their time restraints.
Okay.
I have a legitimate claim. It should matter.
Right. Let's stick to what you are actually doing and what the courts have actually said. Okay. So because what we do is we like to teach people, right? So
yeah,
that's
correct.
Part of the reason why I brought you on is you said that you're in SCOTUS. So I want to know exactly how you got there, not the story. I want to know the paperwork that you filed. I want the people to understand what they can file to follow what you're doing.
Correct. Unfortunately, you need to understand how you can smash them in the mouth so hard, like misprisons of felonies and all of this, to turn your state case.
About the story. We want to talk about the process.
No, it's not my story. Kirk, it's not my story. It's how you can take state to federal. The biggest thing is how do you file into federal?
You're talking about, well, I'm already in SCOTUS. I have standing in SCOTUS. Where is that? How did you do that?
Oh, I got you. Oh, yeah, I had it on my laptop here. I'm in
the paperwork.
I'm in pro per. Correct. I think we're a little off sync here, but the bottom line is I did help. I was helped by Gentry. He does have some good stuff, but the point of the matter is I asked for relief and remedy, and the appellate court refused. So then you have to do a rehearing.
Again, you keep wanting to tell the story. I want to know how, the process. How did you ask for relief and remedy? What kind of document did you file? What's the title of the document?
Oh, there it is. Okay, I got you. Declaratory judgment. I'm not even suing anyone. I'm on the administrative side.
Under Rule 5.1 of the Federal Rules of Civil Procedure. And you have to file something else. Actually, your suit has to be filed, and then you attach declaratory judgment to it. And declaratory judgment is where, hey, this statute, this rule, this policy is unconstitutional, and I'm asking a higher court to declare it as unconstitutional before we proceed with my current suit. That's how declaratory judgment.
When a state judge, aka judge, lies to you and I have his signature, you have no remedy relief in that state when you ask him to recuse himself, and you filed on him in the judicial qualifications. So the point being is I own his ass. I turned to federal. I asked for a mandamus, and federal and appellate refuses to have remedy relief. And I submitted his lies in equity relief. In equity. He doesn't believe I'm in equity.
Okay, so you skip right over stuff that we're actually wanting to hear. How you did this. You keep trying to tell the story. We don't want the story. We want the process, the actual paperwork. So we're talking about declaratory judgment. You say that you own the judge. Where's the paperwork that says that you own the judge? Because you don't. So stop saying that you own the judge. Okay? These are types of things that are, I don't know, not consistent with law. Let's put it that way. And how did you go to the relief and remedy? So I'm going to bring you back on again. Let's go back to that.
Okay. How I got there was a motion to compel. He gave me the state court records of motion to compel. I'm using his compelling of my case because he took over from a judge that retired.
Okay.
So the point is the judge that retired.
Look, Brian, stick to the timeline and the documents, not the story. Okay, we're trying to teach process.
I understand that. I understand that. My case is very case specific, as all of us. The point of the matter is when
that's why we're talking process. Your case is irrelevant. Correct. We want to stick to process. What process did you use? Okay, you said you're seeking. What was the next step you did?
Precisely. Thank you. You gave me that platform. When I knew that he sanctioned me illegally on federal law, I filed a complaint against the judge. And it was 11 ethical, not legal merits, which you talked about judicial canons. 11 judicial canons were violated. Guess what? The judicial qualification says these are legal matters.
The next step in the process. Let's stick to process. I
objected, and then I turned federal.
What was the name of that document? How did you do that? What was the process you did to object?
Well, as the moving party, you object to the ruling of how the judges. I filed a motion to final order with a parenting plan, and again, I took out Title IV funding, and he said overruled, denied, and that's where I pivoted. So, as the moving party, when they object to you just trying to defend your child, that's what happens in state court because they care more about the funding of federal.
We go back to the state court stuff. We're over here in your. We left off basically, yeah, right, Chris?
Yeah, I shift gears so much because again, I haven't been in a.
So we go from declaratory judgment. What was the next filing?
Got you. Yeah, mandamus. Writ of error and writ of mandamus. Okay, there you go. Thank you. Keep going. In the appellate court in St. Louis, by the way, I bypassed state, so I'm in the circuit.
Up there.
The circuit had no transparency, and for the record, the only thing that I did wrong was when I said for a rehearing, it should have been en banc like Gentry did. I didn't do en banc. By the way, en banc means the entire circuit judges, folks. So unfortunately, I just had my panel deny me on rehearing, which, by the way, 2 of the 3 are Obama appointees. So they denied rehearing, and that's how I got to SCOTUS. There you go.
Okay, no, hold on. Before you jump there, how did you get to SCOTUS? What was the next filing? Name of the document.
Oh, you have to, when they deny you in an appeal, so you're appealing whatever the decisions are, and you know in law that they're wrong, you have to file a rehearing and do en banc, and Gentry can take over from here because at this point, that's the entire circuit of, whatever you're in the
you're talking about 7th courts, but you the stuff that you post on.
No, I'm talking appellate. I'm talking circuit court right now. Yes.
So you're in the Supreme Court appellate division?
No, I was denied rehearing in the 8th Circuit Court of Appeals. Hence why I'm SCOTUS.
Supreme Court.
It gave me standing in the Supreme Court. Now the clerks, which Gentry can explain because we talked about it before all this other things.
Okay, you start out in a state court and you appeal to a state court. And then now all of a sudden you're talking about the 8th Circuit Court of Appeals.
No.
How did we get from the state appellate court to the Supreme Court of 8th Circuit? How did we get there?
I went from a state court and I took the. That's okay. It's okay. I'm shifting gears so fast just because I shouldn't. I wanted to be more specific. So I took the family court in Kansas to the federal court in Omaha. They're 2 different circuits. The federal court judge in a different circuit protected the other circuit. Then I filed an appeal. The appeal said denied. Then I said rehearing instead of en banc. It was just the 3 justices. and they denied me, which gave me SCOTUS appearance. By the way, I filed to remove my case in May of 2017. I was SCOTUS in November.
So you're already in front of SCOTUS then?
May of 2017, and I was SCOTUS in November 16th of 2017. Correct. That's how fast you can move the process if you know how to work the judiciary.
Do you have an attorney that's doing this for you, or are you doing this on your own?
No. I'm a father that I don't want to fight these people. They're ins legis. I'm tired of it.
No.
I just can't see my daughter.
Do you have an attorney that's helping you with this, or are you doing this yourself?
I'm doing it myself, but I will admit Gentry was helping at the very end. I have a lot of other sources, but again, there's no attorney. So you guys can chime in. In all honesty, this is how you fight for your child, folks.
Let's hear from John for a minute. So you're not trying to stay away from specifics of the case itself, and see if we can, because we're trying to teach people process here. What document do you need to file? How do you move it through the court system so that you can get your relief, your justice?
Let me, and I think this is kind of a good time to walk people through this process. It's actually not that difficult.
Right.
Kirk, can you see my screen here?
Yes, sir, I can.
Okay, so this is a case I brought against the state of Tennessee in the Middle District, Tennessee federal court. And so my first step was to file a complaint in federal court. And in this particular case, I just wanted the Board of Judicial Conduct to provide proper oversight of judges. And the state decided they didn't want to do that. They just wanted to dismiss my case. And this is a great learning point. But just to go through the process a little bit more. So the first step when you file in federal court is you file the complaint, but along with the complaint, a summons for each defendant in the case, and you can download a summons from the district court website, whatever district you're in. It's a very simple form. So for each defendant in the case, you have a summons, and you take that summons and a copy of the complaint for each defendant that's going to be in the case, and you take that to the clerk's office, plus one copy for yourself. And because I'm suing the state, I also have to serve another copy on the state attorney general, even though he's not a defendant. So I have all my copies of the complaints and a summons for each defendant, a copy for the state attorney general. And the clerk will do a raised seal stamp on the summons. You take that raised seal stamp and you attach it to the complaint and you send it to each defendant. So that's your step one. Then the next step is you provide proof of service. So when I sent that to them, I sent that to them via certified mail, which is allowed in the state of Tennessee that you can serve notice by certified mail. So then you take the green card and you attach and you send that to the clerk's office, and you attach a document that says proof of service, and you say, "Here's my green card. I served these guys. So now we can begin." So the next step was the judge came in and she said, this case is exempt from customized case management because I'm pro se. And so I challenge that and I say that's unconstitutional. It's denial of equal access to the courts. That rule, according to the Middle District, Tennessee, that says cases are exempt from customized case management, it's not constitutional. I contest that. They denied me. So then we went through, several memorandums and motions, and a couple of key ones I'll just mention in here is a motion for an evidentiary hearing. And this case was about going against the state and going against bad actors, and the state's going to really push hard back on that. They don't want to give you a chance to answer. But you go through the step and you say, I want an evidentiary hearing. They'll deny you that. Then you go, I did some other actions. I did a emergency. I wanted a temporary restraining order to keep them from destroying evidence. This is another key point. When the defendants come back, and in these cases they always will, they're going to file a 12B motion to dismiss. Mm-hmm. Pursuant to Federal Rules of Civil Procedure, Rule 15A1B, you can amend your complaint without leave of the court.
Okay, and I want to break in right there because this is the key part. Okay, John is filing his paperwork, right? And he talks about the first thing that they file is this Rule 12B motion. That's exactly what I'm trying to teach you folks right there. That personal jurisdiction and subject matter, that notice of special appearance, that is a Rule 12B motion. That is the first thing that needs to be filed, and no matter what case you're in. So if you're in traffic court and you do, hey, you ain't got no personal jurisdiction, you ain't got no subject matter jurisdiction, and the reason why you don't have personal jurisdiction because that's a bill of attainder. That is human trafficking. It's human rights violations, human trafficking. More than likely, they will just dismiss. But if you walk in there and say, well, yeah, I'm going to plead not guilty to that. You know what you just did there? When the judge reads that, oh, well, you were speeding on such and such day. Do you understand? Yeah, I understand the charges. Boom. What understand means is you stand in agreement with that charging instrument that he's holding there that he just read off to you. So before you go to court, you file this notice of special appearance objecting to the personal jurisdiction and the subject matter jurisdiction. And the standing, it just blows them because they don't have any standing. So back to John here. Go ahead. This is exactly what this is what they do. And this is the exact process that we need to do. And when you skip this step, it's called general appearance. And laches occurs. Look up laches. Okay. LACHES. That jurisdiction latches onto you and they proceed with the charging instrument. So if you don't follow this, because every single one of them do it, when we file in federal court, this is the process. Whether they have grounds for objecting to the personal jurisdiction or subject matter jurisdiction or not, it's the first thing that they do, no matter what. It's like a turning the light switch on and the light comes on. It's the same thing. That's what they do every time. So turn it around and do the same thing to them, no matter what case you're in. So back to you, John.
One of the keys that, doing this amended complaint, as soon as they file 12B, they're going to say this case should be dismissed and here's why. And so you read that very carefully. You look at all of the bullshit law that they cited that's not applicable, and then you amend your complaint. And you don't have to ask the court. You just amend your complaint and say, here you go. So I filed my second amended. Well, I actually did another amendment in there, and then I did a second amended complaint. And then there's a bunch of responses and motions that go back and forth between the court. And the court will issue various rulings. And in a lot of district courts, your case will be assigned to a magistrate judge, as my case was. These magistrate judges are gatekeepers to prevent the district court judge from violating the code of conduct for federal judges. They want the magistrate judges to do that. They want the magistrate judges to violate the code of conduct for federal judges so that the district court judge doesn't look bad. So This is a key point. Whatever the magistrate judge issues an order, you always object, period. You always object to it. Now, a trick that they have is in the Federal Rules of Civil Procedure, I think it's Rule 72 off the top of my head, you have to object within 14 days. And if you don't object within 14 days, then that order stands. Now, here's the extra trick on top of that. If you don't object to the magistrate's orders and to their report and recommendation, and the district court judge accepts it, and then you file a notice of appeal to the U.S. Court of Appeals, the Court of Appeals is going to come back and say, well, you didn't object to the magistrate. And so you can't skip that appellate process because the district court judge is the appellate process to the magistrate's rulings. And so then you go to the circuit court and you say, well, I want to appeal this case. And they're like, well, sorry, you didn't object to the magistrate. We don't have jurisdiction on this. You skip the appellate process, so you're done. We're not even gonna consider your appeal. So this is critical, is object to everything that the magistrate judge does, object to everything that the district court judge does. And then that gives you standing to go into appellate courts. And so you go through all, I mean, I had kind of a lengthy document, and I've seen others that are more lengthy.
Now this is your personal case here?
Yeah, this is, well, it's not a personal case. I'm demanding reform of the state of Tennessee in this case. So I'm fighting, in this case, I'm fighting to restore the principles that our country was founded on. And I'm asking for due process to be restored. You know, that's what this case is about, is to reorganize the board of conduct that oversees judges because they're not doing their job, to get rid of unconstitutional laws because these laws are protecting corruption. That this is not personal, you know. I'm not anything for money.
You're the one filing the paperwork, and you're the one making the arguments. That's what I mean by personal. It's not this is your case.
So there's thousands. I mean, this going through this docket, I've written thousands of pages into this case.
Yes.
So then, you know, they come in and they issue their orders, and they do their final entry of judgment, and then I come right back in and do a notice of appeal. I pay them their $505, and then it goes to the appellate court. And so then I've got. I'll jump over here real quick.
Well, I was going to have Chris there, so can kind of wrap that up and have Chris do his own.
I won't. So I went to the with this case. I went to the Sixth Circuit Court of Appeals. And I petitioned for initial hearing in law, as Brian had said. You know, here's a pretty important case. I've proven that we can enforce our right of due process. I've proven that the state provides no oversight of the judiciary. I've proven that the state has enacted unconstitutional laws. I think you guys should hear this in bonk. And they said, no, we don't want to hear it in bonk. And so I took it to the Supreme Court before judgment, and that's where I am right now. We'll see what SCOTUS says. Maybe they'll say that too.
And it's a process. And, you know, part of that, what Chris is going to maybe explain here is that process, how we are torn and using the wrong scales. And he's going to talk about all this, how this ties together. So, Christopher?
Okay, let me just, I'm going to go over one thing as far as this is the scale that's also used in traffic court. And I'm more of a kind of a choose my battles kind of a guy. So the last time I went into traffic court, I had been pulled over for speeding. And yes, I knew I was speeding. I think it was 78 and a 75, or I'm sorry, 78 and a 70 or something. But was late for work. So basically, the long and the short of it is I go to traffic court, right? And I know that I'm on this scale. I know I'm not on this scale. So when the judge says to me, yes, you know, Mr. Hallett, how do you plead? And I just looked at him and I said, Your Honor, I don't have a good excuse, so please don't force me to come up with a bad one. But yes, I did it. And I owned it. And believe it or not, you know what I walked out of there with? $10 in costs. And no points, no nothing. Just because I didn't waste his time. So when I talk about how do you move your interest in this scale, okay? The longer this time takes, okay, the more stuff they can put over here on the pedestal, okay? That's why they motion for extensions of time, right? That's why they try to draw this out. To move this interest as far out from the fulcrum as they possibly can, okay, to torn your stuff, right? Well, again, that's an improper application of this scale, because this scale is not designed to be used that way. This scale is designed for one purpose and one purpose only. When it comes to, like, for real property, there's death in the family, and you're talking like probate. So because those things require calculations, right? And John, I'm sure you've done more than a few of these. So when you're talking about probate and you're talking about how you divide up each person's interest in the estate or the stuff, right? That's the proper usage in law for this scale. Okay. Now, what John's talking about, what Kirk's talking about, and when we walk into court, everybody perceives this scale. Why? Because it's number one, it's the one that's on every attorney's business card, and it's the one that's outside the courthouse. If they had this scale outside the courthouse, you would know what's going on, right? Well, that's not what happened. So when you walked into family court expecting this scale, and you got hit with this one, not even knowing what it is or how it works, you're standing there scratching your head going, what the hell just happened? Well, how we got to that was we took this over time, this thing called prosecutorial discretion, and the attorney said, hey, we're going to expand that to give these agencies prosecutorial authority, right? That means now they have color of law, right? And they rewrote all these guidance documents to reflect this and basically torn all of your interest in stuff and take it wherever the hell it was they were taking it. Well, that's the usage of the scale in that method with that methodology is repugnant to our form of government because you cannot be deprived of life, liberty, or property without due process of law. That scale. That's the one you walk into court and you say, I'm here to go to court. And you got your little boxing gloves over here and this dude's down here and you got your boxing gloves on and y'all are going to duke that out. Well, guess what? That's not where you are. So when you walk into family court and you've got these silver bullets, Kirk, you're going through this right now. Nate went through this. I went through it. And they fire that little silver bullet at you, right? What do? What's that do? That severs your interest in the stuff. You're no longer connected to the stuff. So as far as this process, you're not even in it anymore. You're like way over here, yelling and screaming. You dumbass, what are you doing to me? Blah, 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 blah. Well, this is how you end up feeling like you just had your rear end handed to you when you walk out of family court. Because guess what? That is exactly what happened, right? So when it comes to the unlawful attornment in severing your interest in your children, which are, by the way, this is not even the right scale, which is part of my systems analysis in my report. And when I pointed this out and said, by the way, this came from Parliament. This is what Parliament used to do. This is the practice we declared independence from as far as mock trials are concerned. So when you read the Declaration of Independence, which is why it's the authority in my report, it's not a piece of the appendix. It's not an exhibit, okay? And, of course, Congress knew this. They've been there a while. I would say they would understand because guess who is in Congress? And when I found this out, I was like, well, we have a problem there. We have somebody called a parliamentarian. Probably spelling this wrong, but who gives a crap? Okay, so we've got this parliamentarian in Congress telling them, oh, yeah, you can use this scale here. It doesn't matter that it's not what the Constitution and what the actual due process that Congress wrote says, but the parliamentarian says, yeah, you can do this. So you're finding out where it came from, and here's your answer. This guy who we threw out of here 230 years ago. Remember, or in the the War of 1812 and all that history. We talked about that earlier on the phone. So because this little bastard weaseled his way back in there again, right? And he's got a little seat there in Congress somewhere in the Capitol building. We need to get rid of him, right? Who do we replace him with? Well, we need somebody in there who knows and understands American jurisprudence, has evolved. And I've suggested loss prevention. Why? Because that parliamentarian, in all of his repugnant crap in trying to take us back to where we were 230 years ago, that is an attack on the integrity of the court, the integrity of the process, which means sacrifices public trust. Guess what that has in common? Okay, so when we talk about what I used to do for a living, what we equate in the private sector as consumer confidence, okay, guess what? That equals in government public trust. Okay, well, we've already declared 230 years ago that parliamentarian is incapable of protecting the integrity of the inherited emolument, the bench, the seat in Congress, the seat in the White House, and so on and so forth. Why? Because of the misapplication of the process that was intended for dead people, basically, and gave it prosecutorial power to literally usurp what the documents say. The Constitution outlines this process. Okay? That's basically what it outlines. Okay? So that's how we got here. Now, again, like I said, this was just my solution, my recommendation based on my analysis of this problem, because in the corporate world, without consumer confidence, there is no corporation. There's no business. There's no nothing, right? Well, public trust is the exact same thing. If there's no public trust, there's no government, there's no nothing. And they said, okay, give us some reporting. That's what I'm doing now, is the original judicial report, which pointed it out. Now the follow-up reports, the Weaponized Family Court series, I'm answering the service. And of course, I'm sure some of you have seen there has been some people pissed off about what I'm doing and how and why I'm doing it. And everybody thinks there's a whole lot of money changing hands. I got some news for you. I don't make my money doing what I do when I make my reports to the congressional committees. That's pro bono. My work in the courts, pro bono. My work in the private sector, working for my other clients that you guys don't even see, that's where I make my money. And that ranges in services from showing them proper vendors, where they can buy something that they're normally using but get it cheaper type of stuff. Help them organize their paperwork, help them organize a profit and loss statement, stuff that big companies have the ability to take advantage of, but little mom and pop shops don't. So I've started to provide that service. And guess what? My clients make a lot more money taking my advice than they do, just trying to kind of wing it. Because that's, like one guy who's he's a good painter. I mean, there's this guy, very few people I've seen can lay paint on a car like this guy. But when it comes to running his business, probably not so much. So now, because I've known him for like a long time and we've built that relationship, he's like, dude, help me out here. So that's what we did. We put together a comprehensive business plan for him. He's following it. And at the end of every month, I show up there with his reports. We go over pretty much his entire shop from stem to stern, go through the books, make sure everything is as, there's no variances, everything is at zero, and transition into the next month. So at the end of the fiscal year, he can take those piles, those 12 P&Ls, turn that into the IRS and not even skip a beat. He's not going to be sitting there for weeks at a time trying to figure out how the hell to do his taxes. It's already done. So hopefully that'll answer some questions about the speculation about what I do as far as my relationship with government is concerned. I told him, I don't want your money. I'm going to show you what I can do. What you do with that is up to you. And they're doing it. So as long as they're doing it, I'm going to cooperate.
Can I touch base real quick on a comment, Chris?
So certainly, John.
So somebody made the comment looking at my docket, and they said that must have cost thousands of dollars. It didn't. It cost me ink and paper and my time.
Mm-hmm.
And I've gotten faster and faster at writing these things. And I'll tell you, it's not that difficult. I am the king of monkey see, monkey do. I just go out and I Google and find the document that I'm looking for, and I look for a credible source, and then I model my documents after theirs. Let me give you a really quick example of what I'm talking about. So there was the attorneys for opposing counsel were asking for attorney fees to be awarded in appellate court. And I looked at the law and the rule that they asked for those attorney fees. And I was like, this is extortion under color of law that they're trying to get from me. And I'm not going to stand for this. And so I went to the federal court and I said, I would ask you guys there's a federal crime in progress right now. I would like you to stop this. And so the proper way to do that is to do a restraining order against them. And this restraining order works for anybody. So I just Googled restraining order, and this thing logged me off. Sorry, guys. Let's go. Take me a minute. Okay, it's back in. This thing is, and by the way, in federal court, when you file a motion, most district court local rules require that you file a supporting memorandum along with the motion. That's a very key thing to know, is if you're going to motion for something, you got to support it with a memorandum of law in most district courts. So I went out and I found a Department of Justice temporary restraining order, and I looked at how they did their temporary restraining order. So this was the memorandum, or this was the motion, I think, that went along with it. So here's my plaintiff's emergency motion for a temporary restraining order, and then along with that, I did a memorandum to support that. Oh, this is kicking me off, but I'm not gonna bring it up because I don't want guys sitting here around picking up documents.
Technical issues. It says somebody said it shut down. Zoom meeting.
But you guys can find.
Yeah, I was having a hard time over here too, but it's still going.
All of these documents that
I don't know what's going on over there.
What did we lose?
Okay.
I'm showing 37 viewers on.
No, it's saying everybody's saying they're nearly
No,
said
it's shut down.
Yep. It's shut down and it's still
it's still showing live. What the heck?
You're still up. Well, shnikes.
Okay,
and it's
still showing live. What the heck?
You're still up. Go back and
okay.
Shnikes.
I don't know. Something weird happened over here too. I was typing stuff in.
Here we go.
Trying to explain the three terms: in propria persona, sui juris, and in personam. What those actually mean. Weird happened over here too. I was typing stuff in. Trying to explain the three terms.
Yeah, sorry about that. I thought I muted it.
So yeah, I don't know. I was just trying to explain that stuff. I don't know if it made it into the comments or not, because it's funny, you know, when you start putting this kind of education out there to how to actually effectively defend yourself and shut this shit show down that they put everybody through. They don't like it. They don't like us educating you folks out there how to do that, what the proper process is to effectively defend your rights.
Right.
Claim usurpation of power and deprivation of those rights. And it's fairly simple, like what John was just saying there. You know, these little documents, I mean, they're not hard. The hard part gets into is the brief, the memorandum, and the points of authority that he was just talking about.
Mm-hmm.
You know, and those are things that we can help you with.
Yeah.
As far as how all this works, it's suggested that I'm going around telling everybody that I'm representing clients in court. That's not true. Do you see the words attorney at law on that business card anywhere?
Nope.
No. So I take cases that are currently either in motion and or already adjudicated from the state level, and either make those findings to the federal court if there is a federal case, like in Utah, or that particular state's Department of State or Lieutenant Governor. Come to find out, not every state has a Department of State. Again, this is a process that is not completed. It was the forefathers started to construct it, but it never got finished because the bar unions, right, came in and laid claim to it, right? They said, we're going to do this our way. And how we fell back into that same trap again, dude, well, like I said, that's politics. Well, we've already seen the dangers of politics and a politicized judiciary. That was even discussed back, what was it, 1784, 85, 86, and 87, I believe, in the Federalist Papers, where they talked about the dangers of a politicized judiciary and, you know, why everybody was worried about enacting the Judicial Act, because they're like, whoa, hold on there, buckwheat. This is the crap we just left, right? We don't want this crap. Yeah, we don't want that. We don't want it. And after a bunch of convincing, they finally caved in and said, okay, well, we need to adjudicate bad actors, but we're going to be selective about how we want to use it. And that's when basically when the parliamentarian came back into Congress and started putting roots down, right? So that was kind of where I went into. I think we talked about this last time last time we were on the phone, Kirk, where in 1840, a guy by the name of Alexis de Kelville had wrote in this publication called Democracy in America, lawyers in the United States form a power that envelops society as a whole, penetrates into each of the classes that compose it, works in secret, acts on it constantly without its knowing, and in the end, models it to its own desires. Well, guess what? There was a deleterious effect on that because anybody who's ever studied physics knows and understands. For every action, there is an equal and opposite reaction. So while the bar has been trying to pull everybody so far left, guess what evolved over the course of time? This is the bar. This evolved. Loss prevention evolved as an independent practice. The farther the bar tried to take us left, the people said, you know what, we got to keep this sucker from tipping over. Balance that scale, right? Got to keep that balance in there. And so when it came to how to protect the integrity of the inherited emoluments, these guys weren't doing it. So by accident or by proxy or by whatever, it actually became an adopted part of our practice over here. So, as far as where it comes from and how it got here, ironically, those guys created it. So I just think it's funny as hell. I mean, literally gave us the weapons to destroy them with. So that's just kind of the genius of the Constitution. Probably because, like you've said it many times, Kirk, these declared acts of tyranny is the crap we declared independence from, right? While knowing that those old habits die hard, they're going to do everything to try to get you back over there. We want you back over here. Oh, no, we're not. We're going over here. And it just takes so much time for, to reach a point where that sucker is about ready to snap. So when I walked in and said, oh, by the way, we're going to talk about this word, that that emolument, whether it's inherited or not, it was like I walked in and kicked their dog, because in essence, that's exactly what I did. Their methodology in protecting the emolument is just don't talk about it. We're just going to ignore it, like it doesn't even exist. Well, that's not reality. That's not what public trust is. Okay, people have said we want transparency in our government. We want these are the things we want in government. So, ironically, where they're writing pleadings to try to work their process, I'm over here working the exact same process as written in American jurisprudence. I don't write pleadings. I write reports, right? Based on the stuff that Congress wrote and created this practice to do this specific job to regulate the transactions. Oops, Jesus. I got to learn to quit using my finger. Transactions of real property. Okay. And those transactions of real property, it's what scale those use. Remember this one?
That's the equity scale.
That's right. So when I said, look, Congress said that to use this scale, you got to have credentials. Dude, you guys don't even have those things. They're not even there. That's fiction. You're making this up. That's 100%. I think the technical term is bullshit, but I have to still look in the book for that one. But anyway, you got the idea. Anyway, kind of the long and the short of that is, we've been able to successfully, through the reporting, argue that. And I just think it's hysterical. And some people actually got pissed about it. And other than bar members, I can see why they'd be pissed about it. But Congress said, oh, by the way, in the meantime, the only way we can protect you is we need you to go get one of those little bar cards. I said, why? My library card means more than that damn thing. Well, it's the only way we can protect you, so we need you to get one of those. I said, okay, well, I'm not going to use it. So basically, here it sits in my wallet. And the only reason that I put it on the documents is because Congress wanted me to have it. So, okay, Congress, you said I did. And that's basically working with them to do this. And, I had no idea where this went when I started it. I just said, hey, Houston, we got a problem. They said, no shit, Sherlock. I said, okay, let's talk about it. They said, let's talk about it. So we're talking about it. But anyway, I just figured that was kind of relevant at this point in time.
Right. Yeah, I'm trying to get my Law of Nations here pulled up.
Mm-hmm.
Apparently, it's not. I don't have Adobe Reader over here on this other machine, so I'm installing that right now, and I'm going to pull that up and show you guys some things about the Law of Nations and creating of a nation and some of the fundamental principles of law of itself, like I don't know what the legislative branch can actually do, per the law itself, and the law of creating the nation, and depending on your style of government, what certain powers are actually delegated and what certain powers are not. So in our style of government, where we're self-governed, we do vote democratically, but we are not a democracy. We are a republic, and in fact, we are a constitutional republic. So we lay down the law through declarations. Declaration of Independence happens to be one of those, but there's other declarations in our history here, and one of those is Declaration for the Causes and Necessity of Taking Up Arms. So that one happens to be July 6th, 1775. Okay, notice that that's 1775, almost a year prior to the Declaration of Independence. But that is laying down the law of our ideology of our nation. So what rights the people have, not government. So this is getting down to the fundamental law, what's known as the common law, the law that is common to all, which is where the Second Amendment says the right of the people to keep and bear arms shall not be infringed. That's because of that declaration in 1775. That's what the Second Amendment is based on. That's what our founders were talking about when they said the right of the people have the right to keep and bear arms, and that right shall not be infringed. Because what they went through in the revolution, they fought them people. Lots of bloodshed to declare our independence and fight. And I have to be honest, I'm not quite sure that we actually won that. Apparently we haven't, because here we are back to full circle in history. We're back to the same parliamentary practices that we declared our independence from, that are declared acts of tyranny in the Declaration of Independence. Some of those key things. All right, let's see. What are some of the things that we said no are tyrannical in nature or declared acts of tyranny? How about for abolishing the free system of English laws in the neighboring province, establishing therein an arbitrary government and enlarging its boundaries so as to render it once an example and fit instrument for introducing the same absolute rule into these colonies. So what is actually they're talking about there is in 1608, we can go back further, 1495 or 1492 if you want to go back to Christopher Columbus. But the English people basically came over in 1608, 1607-ish, somewhere in there, and established Jamestown, Virginia. And they brought the Magna Carta, the common law of England, with them. And everything's going good for a couple of years. And you read that Declaration for the Necessity of Taking Up Arms, okay? They're talking about how everything's going great between the king and them and the king's nobles and all the servants, and how they even help defend the high seas and without bloodshed, okay? So they weren't even fighting. They were just saying, hey, look, we should be able to sit down and use logic and reason here, and we'll write a treaty. We'll get this signed, and your nation and our nation will agree to this, and we'll be peaceful about it. We're not going to do bloodshed over this. This is completely illogical for, it's even in then at that time, they were pretty civilized people, Have you ever looked at how they dressed back in the 1700s? They were pretty civilized people. So there's no reason why here we are freaking 250 some years later, why we can't be civilized again and go, look, which is what Chris Hallett's done. We've returned to these parliamentary practices. We're back in the circle of history of where we were at the Revolutionary War in 1776. So the next laid down document, declaration declaring our ideology, is the Virginia Declaration of Rights, June 12th, 1776. Now you'll notice June 12th, that's just like 2.5 weeks prior to the Declaration of Independence. So you have to understand these documents are laying down the law of our ideology. Okay, then you have the Declaration of Independence, July 4th, 1776. But there's one other document that's in between there, and it's I believe it's June 28th, 1776, and that's the Virginia Constitution. Now, most of the other states already had their constitutions, but this is where we're laying down the law of our ideology. So this Constitution, most of the other states adopted this Constitution, the Virginia Constitution. Again, Jamestown, Virginia is where we established the common law of England. And so essentially, you have the right to keep and bear arms to throw off a tyrannical government. Number two, you have certain rights as a form of government, a style of government. That's in the Virginia Declaration of Rights. Number three, the Virginia Constitution, which actually has some of the very same wording in the declared acts of tyranny in the Virginia Constitution. And again, most of the other states, the 13, adopted that Constitution as it was written. And then the Declaration of Independence is actually declaring our independence from the common law, or from the King of England. And most importantly is the Roman Catholic Church, the frickin' bar, the Pope, okay, the Crown Temple bar. That's what we were actually, and if you read that, back to that declaration for the necessity of taking up arms, they talk about this admiralty jurisdiction and this ministerial enemy. They couldn't understand why we're having such good relations with the crown, the king himself, and the king's noblemen, and the people that they worked with over there, why we're having such good luck with them and everything's great with them, but we got this ministerial enemy over here that's coming in and screwing us over and attorning us and subjecting us to these bills of attainder, because that's what they eventually called them, admiralty jurisdiction. And it's legislation that prescribes punishment that bypasses your right to due process of law. Imagine that. If you go into court and you don't have the right to a trial by jury, that's a bill of attainder. And I guarantee you'll find that in a statute. And the judge will be sitting there saying, well, Title 16 says, or Title 32 says, title this. That's not law. This is law. And in fact, you can't codify due process of law, because due process of law, we do. We establish justice. We ensure domestic tranquility. That's in the preamble to the Constitution of the United States of America. That's
Correct.
What it says.
So that's why I said over the progression of time, right? It was, we're going to selectively decide, okay, based on our rules of our bar, what parts of this due process we're going to practice and which parts we're not. Which is basically exactly what they've done in every one of our cases, because, again, old habits die hard. It is selective inclusion and selective exclusion of relevant evidence and testimony is what they use to steer these cases in the direction they want it to go, which is exactly why they're trying to steer the country in the direction they want that to go. So, it's the exact same thing. And it's all the same people. It's the same thing.
So let's go back to reading these declared acts of tyranny. The next one is for taking away our charters, abolishing our most valuable laws, the common law, and altering fundamentally the form of our government. For suspending our own legislators, and declaring themselves invested with the power to legislate for us in all cases whatsoever. Okay, this is where we go to substantive due process of law. Substantive, the substance, the substantive right. So marital right or parental right or your right to keep and bear arms. Where does that right come from? Oh, well, wait a minute. Let's see, right here in the Declaration of Independence, laid down as the law of nature, which comes from the law of nation, which I'm trying to get figured out here. But anywho, law of nature comes from Christianity, the Holy Bible. That's the moral principles, fundamental principles of law. So marital rights and parental rights come from the law of nature, as from the Declaration of Independence. We are creations of God. That's what it says. I didn't write it. That's just how it is. I'm sorry, folks. If you don't like it, I can't help you. But what you need to understand is that doesn't mean that you have to be religious. That doesn't mean you have to go to church. That doesn't mean, what it means is you have rights that no man can mess with. And in fact, the law dictates how you are to be treated, because that right dictates the duty that they owe us, that they owe you. This process, when we say due process of law, that's law of the land. That process cannot be brought into being because the right dictates so. And you, judge, you, attorney, you, CPS worker, you, FBI agent, you have to follow this process because you have a duty here to respect my right. I don't care how you feel, your feelings are. Okay? Right. The law says one thing, and what your actions are here are repugnant to the law. So here's another one. Where is it? Well, that was the three main ones here. There's a couple of other ones here that tell me to say about.
I'm going to explain this in some pretty clear language. Remember, if you look at the book, okay, did you find it?
Yeah, for protecting, this is the great one right here, because this is exactly what E-clause is really about here. For protecting them by mock trial from punishment for any murders which they should commit on the inhabitants of these states. What have we been, John's got a deal there where how many times have people filed in federal court claiming civil rights violations pro se, and those suckers are dismissed. They're protecting them from not just murder, but deprivation of rights while acting under color of law, color of authority, and right back to Chris.
The emolument, right? So what they've done by doing this, remember, we've got the lower form of nobility and we have the higher form of nobility, right? This is the practice. What they have essentially done is they have flipped it. Now they are the higher form of nobility and we are the lower form of nobility as they reach in a torn, take your stuff, you're left empty-handed, and it's gone. It's all done. It's smoke and mirrors, and it's, the hand is quicker than the eye, right? Confidence games.
Parliamentary tricks.
Yes. Parliamentary tricks. Parlor tricks.
You got due process here. Yeah, due
process that, well, what? When you flipped my ass over, bent me over, and reached in and ripped out never mind.
Right.
And the Virginia Declaration of Rights, so many of our state constitutions state almost exactly the same things that you're stating that are in the Virginia Declaration of Rights. Those same very rights were established by the founders of each state across this country. And they knew why they did it, because of what we suffered under England. And when you go back to the Declaration of Independence, it lists out the grievances against the crown. And one of them was mock trials. And what do we have now? Mock trials again. We're right back, just like you guys are saying, we're right back where we started. But here's the thing that I want people to understand is our state constitutions, almost all of them, some of the states got a little more tricky with their language, but more of the common sense states said that we have a right to alter, reform, or abolish the government. And so that's how we do that through the federal courts, is we ask for reform. All of our state constitutions, as part of our right of due process, knowing that judges can be turned they stated that we have a right to a trial by jury. It's in almost every state constitution, and it's in our federal constitution that we have a right to trial by jury, and that's a reform that we're seeking in our work, and certainly in my case is I want us to be able to say time out. Let's call a jury in here because we're not following the common law right now. We're not providing due process, I don't think. And so I'd like a jury to oversee that and return power back to the people where it belongs, not through emoluments and privileges granted to these guys, but our fundamental rights that were guaranteed in our Constitution. And, you know, we just have to ask for it. No, we have to demand it.
Well, it's funny because one of the questions that I got asked when how my proposal was going to work, remember, these states are dependent on this Title IV Social Security money. Remember, they're like crackheads, right? They're like addicted to it. So how are we going to replace that? And my answer was, well, how about from the people who had torn it to begin with? So when you read my report, I just threw in what I referred to as a side effect benefit to the state. States will gain access to a new revenue stream they have never seen or enjoyed before. The economics of this I will leave to your interpretations, but history has already provided the answer. So those two sentences solved the entire money problem. Did it in two sentences. So it's just a matter of knowing and understanding the effects of what you do when you do a systems analysis and you comprehensively explain it, right? This goes back to what we said at the beginning of the show. This is the type of stuff that we want to take to SCOTUS, and simultaneously, I will take directly to Congress through that. So when we make our reports, we're basically going to be calling a meeting, right? We're saying, look, we the people, I think I read that somewhere once, are calling a meeting here. And here's what we are wanting you to do. And as long as the answer that we provide solves the problem, or at least leads us in the direction of solving the problem, then there is absolutely no excuse for any type of denial.
Let me jump on a gentleman's question here. Tim Neath asked, what do you do when you ask or demand and it's not given? So you walk into court and you say, due process isn't being filed. It isn't being provided here. It's not being followed. What do I do? So what I suggest is you file into the court and demonstrate how your right of due process is being violated into whatever state court proceeding you're in. Document it, attach evidence, transcripts, whatever, get it on the record. Then you take that same evidence and you go to federal court and you file a complaint. You're not asking for money. You're just asking for due process, which is your guaranteed right under the Constitution. And along with filing that complaint saying, here's the facts. And by the way, I think, Chris, you're happy to share your work, right?
Mm-hmm.
I'm happy to share my work. I have thousands of pages, tons of motions. You guys just ask me, send me a message, and I'll send you the motion. Just take out my facts, plug in your facts, and you can file this stuff and do monkey see, monkey do. It's not hard. So
that's one of the reasons why I created my group, because everything I've done is posted in that group. So, which kind of cracks me up, because it's like, well, other than the work for my clients, which I have the fiduciary duty to maintain that right of privacy, right? Unless I get permission from them, that stuff is theirs, right? But everything I do in my case, or anything that I've been granted permission to share, I share it right there.
And anything I have is public. It's public record, and I'm happy to share it. You can download it on Pacer, or you can message me and I'll give it to you. But to go back, what can you do, Tim? So evidence it in the record how you're not being provided your rights. Take it to federal court and you file a temporary restraining order or a writ of habeas corpus or a writ of mandamus along with your complaint. You file a motion for an emergency hearing. And more than likely, I'll be honest with you, the district courts are in league with the state courts, and the district courts are not going to help you. But then you take it to the next level and go to the circuit courts. And I also have to be honest. I really think that the system is changing right now. I think judges in the federal courts are becoming more accountable. And just because I got a judge that wasn't willing to enforce my rights doesn't mean that you're not going to get a judge that's going to enforce your rights. I can't come out and say that the entire federal district court system is corrupt. I believe there are good judges out there. And I know a couple of cases where there are good judges out there. So, you got to test the water, take it to the federal court, ask them for help, ask for an emergency hearing, file a temporary restraining order to stop these guys from committing crimes against you, file a writ of mandamus and ask them to order the state to adhere to the Constitution, file a civil writ of habeas corpus. I just learned from Kirk. I always thought that was for prisoners or for criminal conduct, but there's also a civil habeas corpus where you can ask for your rights to be enforced. Is that right, Kirk?
Yeah, the ancient right to writ of habeas corpus, which is actually in our Constitution of the United States of America, is designed the way that, dang it, I hate when it does that. Anyway, is our fundamental right to say, no, what you're doing here is wrong and I want it immediately stopped, because that's what a writ of habeas. Bring the body, bring your papers right now. This is a $5, it costs $5 to file a writ of habeas corpus. Okay, don't file in the same exact court that you're in. You don't complain to the fox that's guarding the hen house that somebody's eating your eggs. Okay, that's what this is the thing. They'll try to tell you, oh, well, you have to file. No. If I'm in a state and I'm in a state court, Article 1 court, and you're trespassing the law, why would I come back to you to say, hey, you're trespassing the law? I mean, come on, that's completely illogical. So the writ of habeas corpus is supposed to go to a higher power, and the way our government is set up is you go tell on them in the federal court, the federal district court. You file your writ of habeas corpus in the federal district court, just like where you go to file your civil lawsuit, okay, federal civil lawsuit, for trespassing the law, because writ of habeas corpus is in the Constitution of the United States of America as a fundamental principle of law. And it's basically saying what you're doing is wrong here. Mm-hmm. They don't want to teach us that is a right that we have to shut down the shit show right now. Mm-hmm. CPS comes in and takes your kids and you say, whoa, you can't do that. Who in the hell are you? Where's your warrant? You have a grounds for writ of habeas corpus right here, right now.
Right. Well, that's another thing that this does. And I tell people all the time, in my group, you can find this report and download it. It's free, right? And it's all over the country. I happen to know, I've got it on good authority. It's on every prosecutor's desk. So when you walk in there and you lay it down, this is a writ of habeas already written. That's the reason I built it this way. Because, like Kirk said, it comes from our ancient right. Yep. So every element, every piece of this document comes from law. So, which is a reason, like I say, for example, the Declaration of Independence is the part of the table of authorities. This is your governing, this is what you're saying, okay, in law. So that's your way of saying, look, dude, I already know what you're up to. I not only see it, this guy saw it and is taking it to Congress.
I want
So
to
doing it. And if my name's on it, if they want to call me up and yell and scream at me, wouldn't be the first time. I'm getting used to it. And you know what? I actually rather enjoy those calls because more than once, by the time we got done with the conversation, guess what happened? They went, so what you're saying is, and then we finished the conversation. Completely different tone in the conversation than what we started with. So
I want to touch base on Jessica's question. She asked if the judge punishes you for going outside to a higher court. If you feel a need to go to a higher court, that judge is already violating your rights, and it's probably not going to get any worse. He's probably doing everything to violate your rights that he can do already. What you stand to gain is a restoration of your rights and to hold him in line. And do not be afraid, because I'm telling you, I know in my case this guy couldn't have been any worse. So I just said, I filed an objection. I'm like, you're not reading my motions. You're issuing rulings without testimony. You're issuing rulings without reading my motions. You're issuing rulings without allowing me to present oral argument. I object to proceeding further in this case. And by the way, here's a federal complaint against you. And it didn't get worse. What happened was it got better. And when I went to the Court of Appeals, they further tried to extort me, but because of what I did in federal court, I think it prevented further harm.
I'm going to post these links to writ of habeas corpus again.
And yes, Jessica, you can get a restraining order, and that was something that I was talking about earlier. If they're perpetrating crimes against you, if they're violating your rights, go into federal court, file a complaint, lay out the facts, attach your evidence to your complaint, because they're probably not going to allow you to attach or present your evidence. So you attach your evidence to your complaint, and you file a writ of habeas corpus or a emergency motion for TRO, temporary restraining order, and you say, I would like the federal court to stop what's happening to me. Don't take my children. Don't take my property.
Hey,
give me a right to present my case.
Yep.
Give me
You
a
people
right
down here are trespassing the law.
Yeah.
They violated my Fourth Amendment rights. They kidnapped my children. I want it stopped right now.
Yeah.
And what happens is they have to actually physically bring you and whoever took your kids, okay, and all their paperwork. And they damn well better be able to prove that you, as a parent, deprived your child of food, clothing, and shelter to the point that it was imminent danger. And the abuse has to meet that strict scrutiny standard again, that there's imminent threat of physical harm or death.
Right.
And when they can't produce those documents and that evidence, guess what happens?
And
shut that shit show down and give you your kids back right now.
And here's a piece that most people miss, is they'll file that writ of habeas corpus, or they'll file that emergency temporary restraining order, and then they just wait. Well, we'll see what the federal court's going to do now. Don't wait. Say, I want an emergency hearing. Walk into the clerk's office and say, I want a hearing right now. This is an emergency. My kids are being taken away. My rights are being deprived. I want an emergency today. Call the judge in right now. And if they deny that, then that gives you standing to go to federal, to take it up the chain. That you were denied evidentiary hearing. They didn't even let you be heard.
What John is talking about, it's called a writ of assistance, or submit for decision. No shit. either one of these are effective to get to that point. So you file a document, and it doesn't matter what it is. It could be a motion for rehearing. If you reach, check your local rules, because some are as low as 12 days. I've seen it as high as 17 days. If it goes past that threshold, you can file a writ of assistance or a submit for decision based on that document that you filed. You literally can push them along, right? And it's these types of documents that we have. I've uploaded a few of them into my group page. I think, John, you've uploaded a few. This type of stuff will help you push those suckers along, because remember, the bar people, they want to extend the time, run you through the loop, another loop and another loop and another loop, and a promise over here, and we're going to fix that over there, and nothing ever happens. So
do not take no for an answer. So you walk into the clerk's office and you say, I want an emergency hearing, and nothing happens. So then you file a motion for court review from the clerk's office with the district court judge and say, I went into the clerk's office and I asked for a hearing, and get it. And then the district court judge sits on top of that, and you do a motion for status update. Most local court rules, but I'm going to sidestep here a little bit. So there's federal rules of civil procedure. Every court has local rules as well. And most of the local rules provide for asking for a status update. If you cannot, if the district court won't grant you an emergency hearing, then you go to the circuit court and say, I would like a writ of mandamus, ask them to order a hearing, ask them to order them to enforce my rights. And so just never take no for an answer, and keep pushing these guys to do their job. I think we're pushing time, aren't we?
Yeah, I was going to go over this law of nations here, but real quick, now that I've got Adobe, I wanted to I was trying to remember what section that was, and I think it was 35, but there was two. One that was like blatantly says, hey, you can't be doing that. So I was trying to pull that back up, the one I shared with you. But there's all sorts of great stuff in this. I thought I put it in. Here's the clause. Where did it go? There it is, in the think tank. So I'm going to do my share screen here now that I found it. Yeah. 30, section 34 and 30. Okay, section 30. I'm right here. Perfect. All right, so let's go here. Screen share. Is it? Nope, this one. Okay, so now you can see what I have on this other computer. So let's see, section 30. There's 29. Section 30. Of the support of the Constitution and obedience to the law. Okay. The Constitution and laws of a state are the basis of the public tranquility. You know, Chris and I, John, we talk about that. We, the people, you know, in order to form a more perfect union, establish justice and ensure domestic tranquility. That's what they're talking about right here. Again, this is prior to, you know, this is Vattel, written in, he started writing it in 1714 through 1774. Imagine that. So why our founders, some of the words that they use in the sayings is directly from right here. Okay, the law of nations. The constitutional laws of a state are the basis of the public tranquility, the firmest support of political authority, and a security for the liberty of the citizens. But this Constitution is a vain, number 10, I think, phantom, and the best laws are useless if they be not religiously observed. The nation ought then to watch very attentively in order to render them equally respected by those who govern. So in other words, come on, folks, start paying attention to what's happened to your fellow man out here. Get down to them courthouses, bear witness to what's going on, file that writ of habeas corpus, go up there with them to the court and say, yeah, I bear witness to these crimes. This is happening. This did happen to this person. I saw it with my own eyes. I heard their lies. Get out there. Be active. Oh, I got to go to work. I got to go do this. You know what? Our country's way more important. Our nation is way more important right now.
This is where we fell asleep over the last 30, 40 years.
Right. And you can take it with you if you want. I don't mind.
Okay. So let's get more back here, right here, because this is good. Okay. So govern and by the people destined to obey. To attack the Constitution of the state and to violate its laws is a capital crime against society.
I love that.
And if those guilty of it are invested with authority, they add to this crime a perfidious, yeah, say that one, abuse
say
of the power with which they are entrusted. The nation ought constantly to repress them with its utmost vigor and vigilance, as the importance of the case requires. It is very uncommon to see the laws and constitution of a state openly and boldly opposed. Imagine that.
Not anymore.
It's not in today's time, again, because we've returned to that stupid parliamentary practices. That's the key part of what I wanted to read here in section 30 of book 1. But I want to get down to the other one, which was 34, I believe.
I love that, Chris.
This is great right here, guys. Okay, this is dealing with the legislative power, when I was talking about earlier in the show. The legislative power and whether it can change the Constitution. What's going on with this Article 5 Constitutional Convention? Pay attention, real close. Here again, a very important question presents itself. It essentially belongs to the society to make laws both in relation to the manner in which it desires to be governed and to the conduct of the citizens, okay? This is called the legislative power. All political power is inherent in the people. We have the right to alter, reform, and abolish anything at any time, okay? The nation may instruct the exercise of it to the prince or to an assembly. Imagine that, an assembly, okay? Or to that assembly and the prince jointly. Well, we're not in a monarch. We're self-governed here. So the people, the citizens, we get to dictate. We're supposed to vote on that crap. Our legislators aren't supposed to be creating bills and having themselves vested with the power to vote law. No, we the people are supposed to vote it, not them. We'll get into this, okay? The nation may instruct the exercise of it to the prince or to the assembly, or that assembly and the prince jointly, who have then a right to make new laws and repeal old ones. It is asked whether their power extends to the fundamental laws. Fundamental law, the stuff that we the people, establish justice, ensure domestic tranquility, provide for the common defense. We the people do that. That's the fundamental laws, the common law, the law that's common to all here. Whether they may change the constitution of the state. The principles we have laid down the law, declarations, led us to decide with certainty that the authority of these legislatures does not extend so far, and that they ought to consider the fundamental laws as sacred, if the nation has not, in very express terms, given them power to change them. The Second Amendment says it shall not be infringed. That is a, I go back to American jurisprudence, Volume 16, Constitutional Law, Section 100. The Bills of Rights are merely declaratory of the common law. And in that Section 100, it talks about things like shall not. Those are merely declaratory that you don't have any authority. Right here, and this goes back to the law of nations, the law of creation of a nation, our Constitution and the principles of law, fundamental principles. For the Constitution of the state ought to possess stability. And since that was first established by the nation, which afterwards entrusted certain persons with the legislative power, the fundamental laws are accepted from their commission. It is visible that the society only intended to make provision for having the state constantly furnished with laws suited to particular conjunctures, and for that purpose gave the legislature the power of abrogating the ancient civil and political laws that were not fundamental, and of making new ones. But nothing leads us to think that it meant to submit the Constitution itself to their will. In short, it is from the Constitution that those legislatures derive their power. Title 74, Section 201 of the Idaho Code. People of the state of Idaho the people of the state of Idaho, in creating the instruments, these are the instruments, the Constitution, of government that serve them, serve us, okay? They serve us. Do not yield their sovereignty to the agencies so created. That sovereignty is this fundamental law that's been laid down as the law, the fundamental law, okay? Without destroying the foundation of their own authority, okay? Oh, how then can they change it? Without destroying the foundation of their own authority? The law of creation. The Constitution for the state of Idaho creates, that's that due process of law, law of the land. Law of the land means due process. Okay, this instrument creates the process that allows the legislature to come into being. So how can the legislator itself disobey the commands of its creation? It can't. Completely illogical. It's repugnant to the law. It's foreign to our form of government. So there's more there. You want to find, I mean, this is out on the internet, Vattel.
I love that last line. And who would dare to assert that they would not have the right to oppose it? I love that line.
First, the laws of suited particular conjunctures, and for that purpose gave the legislature the power of abrogating the ancient civil, submit the Constitution itself to their will. In short, dang it, Facebook freaking out again.
Did you break it?
The two houses of parliament in concert with the king exercise legislator, but if the two houses, where was that you were talking about?
The very last sentence of that page.
Oh, and who would dare to assert that they would not have a right to oppose it?
I love it.
But if the parliament entered into a debate on making so considerable a change, and the whole nation was voluntarily silent upon it, this would be considered as an probation of the act of its representatives. So it's reprobate. You know, you can't do that.
Right?
What are you doing? You can't take people's kids. You can't deprive people of their fundamental right to keep and bear arms, for the simple fact of the reason why we have the right to keep and bear arms is so that you can't do what you're doing. Plain and simple. That's breaking it down as far as grandma, can understand it, is the right to keep and bear arms shall not be infringed, so that we can say, no, you can't do that. That's what that right is there for. And so these bills of attainder that you create, and this goes back to the very beginning of the show when Lorraine, I was wanting to talk about, how do we get our rights stuff back? We take them back. They're our rights. They don't have any authority right here. They don't have the authority. It's called bills of attainder. It's prohibited. Article 1, Section 9 to federal, bills of attainder are prohibited. So the federal government cannot create legislation that says, if you do this, you lose this. That's a bill of attainder. That's legislation that prescribes punishment that bypasses your right to due process of law and deprives you of your right to a trial by jury. That's all of that. Anything, traffic tickets. Go in there and say, yeah, I'd like to have a trial by jury. Well, you don't get one of those in here. This is an infraction. Well, infractions are bills of attainder. It has no standing in law. It's repugnant. Goodbye. I ain't paying your stuff. I ain't allowing you to discharge the debt off that charging instrument you got. And I don't consent to any of this. You want to continue with this? I'll file a writ of habeas corpus. I'll file suit against you. I'll have you removed from duty. This is where we, the people, need to get and start telling these people what you're doing is wrong. And it's not so much as being a jerk about it. It's, look, Judge, that's what the law says. That's a bill of attainder. As it is written, that is a bill of attainder. So, with all due respect, sir, this has no standing in law. And I don't consent to you attorneying me. That would be an emoluments violation. Start dropping that word on them. See how they like that. So, there's our law of nations. This is 964 pages if you want to endeavor to read this, because this is the fundamental principles of the fundamental principles of law. Okay? This is the law of creation of the nation. And then declarations lay down the law of the ideology of creating the nation. Yep. And then this Constitution is ordained and established as the supreme due process of law. Again, law of the land means due process of law. They're synonymous. They mean the same thing. So the Constitution for the United States of America is the supreme due process of law to bring things into being, like a governor, like the president, like the House of Representatives, so Congress, the Senate, how those functions work. That's what the Constitution does, is the process. Okay? This Constitution only applies to those that are bound by it, not to us. Okay? Our rights are over here at the common law. They have nothing to do with this. That's already been laid down as the law. That stuff's common to all. And Declaration of Independence says it's supposed to be self-evident, right? That law that's common to all is supposed to be self-evident here. Going back to right here what we just read, you can't do that. You don't have that power to trespass the common law, the law that is common to all. So
Wednesday night, we are going to hopefully have Nate back on here, provided he can make the trek in time. And we will discuss the expansion of prosecutorial discretion through the agencies that has ultimately led to the weaponizing of the family court, and explain the effects of E-clause on destroying that weapon, counteracting it. So on that note,
that process.
Yeah, that's the one.
This is what we're really trying to get out there, folks, is the process. But Monday nights are the show where we try to teach you the law, which is what I just went over the last half hour here. The law, parts of the law. Okay. And then you have to have this knowledge in order to be effective in court, in order to be effective to write your brief, your memorandum, and your points of authority, because this is your points of authority. You don't have that authority, sir, ma'am, because the law says you don't have that authority. But you have to know this stuff, and this is why we've split the shows, and Wednesday nights are the call-in show. So I really hope that we can get Nathan on here and part two. John, you got anything over there?
Dude.
John? You turn your mic on, sir.
Oh, sorry. What's that?
I was going to say, did you have anything there in closing? And then we'll turn this over to Ted to close this out.
Thank the listeners out there, the viewers, for educating yourselves. And we're here to help. We will share all of our work with you guys. We encourage you to stand up for your rights and work with us to try to reform the governments to return our rights to us. And man, Kirk, thank you for sharing that, because I'm going to incorporate some of that stuff into my work, because that's obviously the founding principles, you know. So thank you. I learned a lot tonight.
So, all right. One last thing, I just want to give a shout out to some of our fellow friends and within this movement. We got ladies and gentlemen over at the Far From Normal radio show, Jay Moss, Bud Pino, Pete the Real Deal McNeil, as Bud says, and of course Jessica Wiener, and their entire technical staff. We want to say reach out, say hi to everybody over at Restoring Families Internet Radio. That would be Brian Lee and Steve Ball and their technical crew. So tune in and see those guys. Far From Normal tomorrow, 8 p.m. And Restoring Families Internet Radio, I believe, is open mic night Thursday, and their show is actually on Sunday. So just a special shout out to those guys. Thanks for doing what you do, and we hope to see you guys soon.
And yes, I put the thank you out there for coming on tonight, sharing with us, Brian Van Akin, other people that are tuning in here. Share this stuff. Let's get this stuff out there. Let's get folks educated. You know, we don't charge anything. We're not even set up to receive donations. So this is all free, our own free will. You know, Chris, what he does over there, he does pro bono. He doesn't get paid for any of that stuff. Hopefully, once he wins some cases there, and, you know, under their rules procedure that you got to pay attorney fees, Mr. Attorney. So you have to pay the attorney fees. And whatever he submits the bill, even though it's pro bono, eventually it's going to get to the point, I'm pretty sure they're going to start going, no, Mr. Hallett, you need to be compensated for your time, your work, and your efforts here, because it is a lot of work. So again, thank you all for tuning in. My Idaho friends and those that are not from Idaho but are still my friends, Rebecca, and there's Tatiana, and there's a few other people here. So forgive me if I don't name you personally, but I do want to thank you for tuning in. Share, follow, and go in and do the see first type stuff, so that when we do post stuff, you get to see it. And then Amber and Steven over there, that's a group where Chris has his filings. John shares some of his filings in there as well. I share some of my filings in there as well. And then Kirk's Law Corner group, it's a private secret group. It's not real open. So I have other stuff in there that you can read and learn from, especially that writ of habeas corpus. I have a PDF in there that tells you how that ancient right works and what it really means and how it was established and how it came through history. Another one to read is the Treatise on Arrest and False Imprisonment. You combine those two things together.
And you guys can message me through Messenger and let me know the kind of case you're working on. I've got thousands of pages of really high quality legal work, and happy to share. You can take all of my work. I don't care about money. All I care about is restoring constitutional rights. So happy to share.
Ted, it's over to you, brother. Thank you for producing, and we love you.
Let's go. Love you, brother.
Much love to the rest of you out there. We do love and care. We are doing this for us, we the people. This isn't just a personal thing. So,
yep. The kids.
Drain the swamp. Pull the plug and drain this shithole.
Found the drain plug.
Are we off?